Hello and welcome. We're discussing surrogacy law. What is intended for parents, for surrogates, for children? The hashtag for this discussion is pet surrogacy. This is the first public discussion of the Scottish Law Commission and the Law Commission of England and Wales proposals for changes to surrogacy law, which they've set out in a lengthy report and also a draft bill. And the discussion of this topic has been made possible thanks to the generous support of the Scottish Government. I'm Sarah Norcross, Director of PET, and I'm chairing the discussion. People have been calling for a thoroughgoing update of surrogacy law since the 1990s. In 1997, the legal scholar Margot Brazier was asked by the then government to chair a review of the laws regulating surrogacy. And the subsequent Brazier report made a number of recommendations, including the need for greater regulation and the tightening of expenses payments. Now, I think it's fair to say that this report has sat languishing on a shelf somewhere, gathering dust ever since. And there's not been any great appetite from government to reform surrogacy law. So when the Human Fertilisation and Embryology Act was updated back in 2007 and 8, people called for, well, why don't we put surrogacy in there? Why don't we deal with that at the same time? But that wasn't popular. And, PET and others have been repeatedly fobbed off by officials who've said, oh yes, surrogacy, it's in our 5-year work strategy. It's one of those 5-year work strategies that never seems to get to year 5 when perhaps then surrogacy is scheduled. And so there's been, nothing has really very much happened. So when the idea was floated that the law commissions may take on this task and propose recommendations for reform and draft a surrogacy bill, I have to say I did sort of think, hurrah, and this might be a very neat solution and get things moving. Before I introduce this evening's speakers, I just wanted to quickly share some research that PET did into surrogacy. So last year, PET commissioned Ipsos to carry out research into public attitudes and understanding of fertility, genomics, and embryo research. They interviewed a representative sample across the UK of more than 2,000 people. And as part of that research, we asked, do you think that surrogacy is currently legal in the UK if the surrogate is a UK national and living in the UK? And I have to say, we were quite shocked that only 26% of respondents correctly identified that surrogacy is legal throughout the UK, particularly when you think the Surrogacy Arrangements Act has been in place since 1985, and surrogacy has been in virtually every single soap opera line in between now and then. So that was quite a shock. And and also that more than a third of people just said they didn't know, which is, when you've got things to pick from, is always also quite surprising, I think. And we also asked about payment, and so we asked people to say which of the sort of following a range of statements they agreed with. And the most commonly held view when we did that was that reasonable expenses should be paid to surrogates. But again, we saw that a significant number of people rather responded don't know, with 21%. And at a small percentage, 9%, believed that surrogates shouldn't be paid anything at all. So we have Gillian Black, we have Beverley Addison, Alan Brown, and Alan Inglis. Gillian is the Law Commissioner who has the joy of having the responsibility for surrogacy at the Scottish Law Commission. She is a Professor of Scots Private Law at the University of Edinburgh's Law School.
The laws which currently govern surrogacy were passed nearly 40 years ago, and society and families have changed considerably since then. So our recommendations seek to reflect those changes and to ensure that a reformed surrogacy law would respect the intentions of all the parties, would safeguard against exploitation, and critically place the best interests of the child at their heart. While our work at the Commissions is entirely independent from government, our starting point reflects the UK government's view on surrogacy. So Department of Health and Social Care guidance says that the government supports surrogacy as part of a range of assisted conception options. And of course, surrogacy has never been illegal in the UK. So the question of whether the law should prohibit it or not was not one that we were asked to consider. In our review, we considered questions like who should be the legal parents of a surrogate-born child at birth, and how can the law ensure that all parties are protected from exploitation? What payments should be permitted to be made to surrogates? And what provision should be made for overseas surrogacy? And our recommendations seek to address the many concerns that were evident throughout the project, from our consultation exercise and from speaking to those with a direct involvement in surrogacy, or those with concerns for the parties involved, especially the surrogate and surrogate-born children. In the time available this evening, I'm not going to provide an overview of the current picture of surrogacy in the UK and the problems with the current law, although I can discuss that later if any clarification would help. But instead, I want to focus on our recommendations for reform. And one preliminary point I want to emphasise at this stage is that our recommendations very firmly support non-commercial surrogacy. There is no support for a move towards a legally enforceable model of surrogacy with commercial fees payable. And as I will explain throughout this presentation, surrogacy agreements will remain non-enforceable and there will be no commercial or for-profit fees paid to surrogates or to surrogacy organisations. So central to our proposed reforms is the introduction of a new pathway for domestic surrogacy agreements. And this new pathway aims to address two of the most significant concerns with the current law. In the first place, it introduces required screening and safeguarding checks for the surrogate and the intended parents before conception, so long before the child is brought into the world. And that is in stark contrast to the current system, where the state oversight only comes many months after the child has been born, when the parental order is sought. And by bringing that state involvement and oversight up front for the very first time pre-conception, through an administrative rather than a judicial process, we also recommend that the outcome of the surrogacy should reflect and respect the shared intentions of the surrogate and the intended parents by recognising the intended parents as the legal parents of the child at birth. And there was significant support for this change amongst consultees, particularly those with personal experience as surrogates or intended parents. However, there was also much concern and objection, particularly from those responding from campaign groups who are opposed to surrogacy in principle, and their concerns often focused around exploitation and whether it was appropriate for a woman to be a surrogate at all. So to address those concerns regarding exploitation, a fundamental requirement of the new pathway is these preconception screening and safeguarding checks, and they're set out on the slide here. There'll be medical checks for all parties, enhanced criminal record checks, independent legal advice for the surrogate and the intended parents, and implication counselling for the parties individually and together. And the final critical preconception screening and safeguarding will be an assessment of the welfare of the child to be born through surrogacy. And only if all these screening and safeguarding checks are completed will the parties be then ready to move on to the conception phase. So these screening and safeguarding measures will ensure that the decision to enter into a surrogacy agreement is fully informed and considered, and they will be overseen by a new type of organisation, which we recommend should be introduced, and which will be an independent state-regulated organisation, a regulated surrogacy organisation. And I'll say a bit more about regulated surrogacy organisations later. Our recommendations also suggest that intended parents should have parental responsibility, or in Scotland, parental responsibilities and rights from birth. Now, these are separate from the question of who is the legal parent. They're separate from legal parental status. These are the very practical legal responsibilities and rights that enable any parent to care for their child, to have them living with you, to take decisions concerning their care or their medical treatment. And on the new pathway, both the intended parents and the surrogate would have these in respect of the child from birth, although only the intended parents would be the legal parents. So having followed the preconception stages and the screening and safeguarding, if approved by the regulated surrogacy organisation, the parties would move forward to conception and, all going well, to pregnancy and to birth. And at birth, the intended parents would be the child's legal parents. However, as you can see from the slide, the surrogate would also have a right to withdraw her consent. And our recommendations seek to ensure that the surrogate's autonomy is protected. So all decisions relating to the pregnancy and the birth will remain in the exclusive control of the surrogate. Respecting her bodily autonomy is a key plank of our recommendations. So we clearly recognise it's her body and she is the only person who can make decisions about her pregnancy or the birth. So it's critical that the surrogacy agreement will not be legally enforceable. And that means that the surrogate cannot be required to do anything concerning her body or the child simply because of that prior agreement. Instead, she will have the ability, if she chooses, to withdraw her consent to the new pathway. And if she does, then the final decision regarding the child's legal parents and who they should be will be made by the courts. And in all cases, that decision will be based on securing the lifelong welfare of the child. So if the surrogate withdraws her consent after the treatment leading to conception, but before birth, so during the pregnancy, on that new pathway, if she withdraws consent during pregnancy, then she will be recognised as the legal parent at birth. But as is the case at the moment, the intended parents would be able to apply for parental order if they wished to be recognised as the legal parent. It would also be possible for one of the intended parents to be recognised as a second legal parent, as happens in the current law. If, however, the surrogate withdraws consent after the birth, and she'll have a 6-week period in which to do so, then the intended parents will have been recognised as legal parents at birth, and they will remain the legal parents. But the surrogate may then apply, if she wishes to do so, for a parental order, and she'll have 6 months to do so. In either case, the critical thing is that the decision will lie in the hands of the court. And as I said, that decision will not be based on what the adults want or what they've agreed, but very much what the court determines is in the best interest of the child. And that is the paramount consideration in any matter concerning children. In order to proceed on the new pathway, the intended parents and the surrogate will sign a regulated surrogacy statement. And this is a statutory document stating that the parties agree to the intended parents being the child's legal parents at birth and confirming that they've undertaken all the screening and safeguarding requirements on the new pathway. And this regulated surrogacy statement will be co-signed by the regulated surrogacy organisation. And these regulated surrogacy organisations are to be the gatekeepers to the new pathway. Their approval will be required for the arrangement to proceed, and if they don't consent, then the parties would not be eligible for the new pathway. So these state-regulated independent bodies, RSOs, will have a vital role to play in surrogacy under our recommended reforms, and they will, as part of our aim of keeping surrogacy in the UK altruistic rather than commercial, they must be non-profit making organisations. They can't make any commercial gain from supporting surrogacy. They will be regulated by the Human Fertilisation and Embryology Authority, the HFA, who currently regulate and have expertise in regulating fertility clinics and embryo research. And they will be responsible for supporting surrogates and IPs. The RSOs will be responsible for supporting them and ensuring that the preconception screening and safeguarding has been conducted. So the role of the regulated surrogacy organisations really represents a significant shift from judicial scrutiny after the birth of the child, several months after the birth of the child, to an administrative scrutiny and support before conception. The new pathway will mean that in most domestic surrogacy agreements, intended parents will not be required to apply for parental order, but the parental order process needs to be retained alongside the new pathway for a number of reasons. Firstly, if the surrogate withdraws consent, then either she or the intended parents may need to seek a parental order. And thereafter, we are aware that some surrogacy teams may choose to make agreements outside the new pathway, and they would be free to do so if they wish. It's also the case that a parental order would be required where there's been an international surrogacy arrangement, as they're not eligible for the new pathway. So closing off the parental order process would stop a court from making a decision about legal parental status in the best interest of the child. So we need to retain the parental order option, but we recommend a number of reforms. And the most significant reform that we recommend is for the court to have the power to dispense with the surrogate's consent so that it can grant the parental order. And at present, the surrogate must give her unconditional consent for an order to be made. And we recommend that the surrogate's consent is still required, but that the court should be able to dispense with that where the lifelong welfare of the child requires it. And this is similar to the test used in adoption proceedings, and it shifts the focus from the wishes of the adult, as at present, and places the best interest of the child at the heart of parental orders. So this change will only apply in respect of surrogacy agreements that are entered into after the new law comes into force. Another recommended reform to the parental order process is that although the 6-month time limit for applications should remain, there should be specific statutory provision for late applications, and that simply reflects the approach taken by the courts in England and Wales to date anyway. We also recommend a number of eligibility conditions for all surrogacy agreements, whether on the new pathway or the subject of a parental order. And in fact, many of these eligibility conditions are the same as the current requirements. So the intended parents should be at least 18 years old, they must be in a relationship, they must have a genetic link with the child, and they must be domiciled or now habitually resident in the UK. One new eligibility requirement that we recommend is that the surrogate must be aged 21 or over. So there's currently no minimum age for surrogates, and we felt that 21 struck a balance between respecting the surrogate's autonomy and her right to make her own decisions regarding her body, and protecting younger women from the risk of exploitation. Another change that we recommend for both situations, the new pathway and the parental order process, is that the surrogate spouse or civil partner will not be the legal parent in any situation. I'll now turn to the important issue of payments to the surrogate, and the recommendations we recommend here will also apply equally to surrogacy agreements on the new pathway or where a parental order is sought. For the new pathway, the RSOs will play a crucial role in ensuring that intended parents and surrogates know what payments are permitted. And where a parental order is sought, then the court will retain its role in scrutinising payments that have been made between the intended parents and the surrogate. Now, the law is currently unclear as to what types of payments are permitted, so there's no definition of what constitutes expenses reasonably incurred, which is the current statutory wording, and there's no effective means of enforcing limitations on payment. So our recommendations are intended to ensure that a woman who becomes a surrogate does not end up financially better off or worse off as a result of her decision. And in this way, the law can help protect women against exploitation, both by ensuring that women do not feel pressured into becoming a surrogate for financial gain, and conversely, that they do not bear the financial cost of the surrogate pregnancy. To ensure greater clarity and transparency, under our recommendations, the law would set out specific categories of payments which the intended parents are permitted to make to the surrogate during that period, that protected period. And if a payment is not permitted, then it would be prohibited. Now, the protected period in question will run from the time of the surrogacy agreement until 6 weeks after the birth of the child. And during that time, the permitted payments, and I've set them out in this graphic here, would include medical costs, any travel and accommodation for purposes linked to the surrogacy, pregnancy-related items, including clothing, domestic support to help cover things that the surrogate would usually do but does not or cannot do during the pregnancy, including childcare and work around the house. The intended parents would also be able to pay for any lost earnings, and for the surrogate and her family to have a recuperative holiday after the birth of the child. These, however, are not compulsory. It's entirely up to the intended parents and the surrogate to agree which payments will be made, if at all. However, the intended parents are required to offer to pay for the surrogate's life and critical illness insurance and for the screening and safeguarding checks required for the new pathway. These categories are intended to reflect the costs which are typically incurred during a surrogate pregnancy, and any payments outside these permitted categories are prohibited. So notably, that includes payments for carrying the child and for enabling the intended parents to raise the child, as well as any payments for compensation for pain and inconvenience or for general living costs. And we consider that prohibiting these categories of payments really protects against the risks of exploitation or of women becoming surrogates in order to benefit financially. Prohibiting payments for carrying the child also ensures that surrogacy continues to operate on a non-commercial basis. There's no for-profit motive. We're also aware that limits on payments are only meaningful if there's a mechanism for enforcement. So we recommend, both for the new pathway and the parental order route, various provisions for enforcement. And on the new pathway, intended parents would need to make a statutory declaration, a stat dec, after the child has been born. And that would be in relation to the payments they've made. If they fail to make that declaration, or if they make a false declaration, then they may commit an offence. There may be criminal consequences of that dishonesty. But where they honestly declare any overpayments, or indeed honestly declare that there have been no overpayments, then there would be no consequences arising unless they have made overpayments, in which case there may either be a civil penalty, a financial penalty, or the regulated surrogacy organisation may face regulatory sanctions if it's not done what it should do to support the intended parents and surrogates in complying with the limitations. Where a parental order application is made, then details of the payments would have to be declared to the court. And similarly, if there is any dishonesty there, then an offence may be committed. We don't recommend that the fact of making or receiving an overpayment itself is a criminal offence. It would only be any dishonesty, lying that goes along with that, which is the problem. So simply the fact of making or receiving an overpayment would not be a criminal offence. And that is very consistent with the view that's been taken in previous reviews of surrogacy, that such an offence would taint the birth of the child with criminality, and that is not in the best interest of the child. The final matter I want to touch on in my closing minute is the creation of a surrogacy register, and it's vitally important that those who are born using surrogacy have the opportunity to learn about their genetic and gestational origins. Research shows that having access to such information can contribute positively to the quality of relationships and psychological well-being within the family. And we know that openness is encouraged in surrogacy and that many surrogate-born children know about their origins and have a continuing relationship with the surrogate, but that is not always the case. And we therefore recommend the introduction of a surrogacy register held by the HFEA so that surrogate-born children can obtain, at an appropriate age, information on their origins. So taken together, our reforms would improve the current law and benefit all parties by respecting their intentions and seeking to put the best interests of the child at their heart. However, our work here is done as the Commission, and it's now in the hands of the UK Government. The decision as to whether to take forward our draft bill is, as with all Law Commission projects, one for the relevant government, and we await with interest their response to our report.
So next this evening, we have Beverley Addison. Beverley is a senior solicitor and collaborative practitioner at BTO Family Law. And the focus of her presentation will be what difference these proposed changes may make to the intended parents.
So for those I've not met before, my name's Beverley. I am a fertility law specialist solicitor based in Glasgow in Scotland. So I spend my days on the grounds with intended parents and surrogates who are currently using the parental order process. And so it's been quite exciting for us all to see some change in the law, change on the horizon. I do like to rub it in quite often that the last time it was reviewed was before I was born, so it's always nice to see that there's a bit of a change moving forward. So when I first had a read over the 600 pages of the report, I was happy to see that there were some changes on the move. However, having looked at it in the detail, there's probably not as many changes to the practicalities when we're stepping into the shoes of the intended parents. And that's a good thing and a bad thing for some different parents, depending on what their makeup is. However, in the 10 minutes that I have tonight, I thought I would talk about the four main areas as I see it for our intended parents that they will find the most benefit from these proposed changes. I see that as being the first one being some more options for intended parents to consider, and certainly there will be a big carrot there for UK-based parents going through a surrogacy organisation within the UK. That's the obvious one that we'll chat about tonight. There are also safeguards now to reflect what I would essentially call best practice, which are all the safeguards that we want to see in place for surrogacy organisations and clinicians and everyone that's involved in the process. I was particularly impressed to see improved employment rights. It's sometimes one of the lesser thought of aspects of surrogacy, but the change suggested there is quite helpful for our intended parents. And also more options for dealing with disputes. Luckily, as we know, legal disputes in surrogacy are relatively rare, but where they do arise, they are very complex. And some of the changes that are suggested will give judges more options when they are faced with a dispute at the other end, which I think will be very helpful for them. So the first thing to talk about is the additional options now for intended parents to consider. So if you imagine that you are an intended parent and you're right at the start of your surrogacy journey, with this law now being there, you will have much more options in terms of what to think about of how you want to proceed. Obviously, the new pathway that Gillian's just taken us through for intended parents who are working with a regulated surrogacy organisation based in the UK will have that very valuable carrot there of being the child's legal parents upon birth, and that will, for most couples in that scenario, be enough to encourage them onto that pathway, I would think. However, remaining there with the parental order will still be an option for those that cannot work within the new pathway for whatever reason. There can be a few from my view, but particularly those who don't want to work with a regulated surrogacy organisation for whatever reason, or who cannot. One of the things I've noticed quite a lot in practice, and anyone else on the call that does this for a living will notice that there is very much an uptick in people organising their own families in terms of how they want to do that. I've seen that very much in the co-parenting world alongside surrogacy and known donor world, where people maybe go, not the back door, but there's a lot of Facebook groups and websites where people like to sort of make that connection on their own, and that being there will be another option for them, that they're not sort of left in limbo or forced down that road, but that there will still be that there where we're not cutting down people's options too much. And of course, international surrogacy remaining an option, and I'm aware that we're going to talk about that later, so I'm not going to touch too much on the international surrogacy side, but it certainly remains an option there that's not been majorly affected at all by the recommendations in the report. So when you're an intended parent sitting down to think about what you want to do, you certainly have at least 3 options to consider there, alongside all the various jurisdictions that you might look at when you're looking at a potential international surrogacy journey. Certainly, I think the clearest thing from the report is the safeguards trying to reflect best practice. Gillian's already taken us through the vast majority of these, so I'll not harp on about them too much, but sort of codifying the independent legal advice, implications counselling, having a written agreement, working with a regulated surrogacy organisation where you can, and the various other background medical checks are definitely something that I have noticed in practice that we're all aiming for anyway at this point. But it's nice to see those sort of codified and given the stature that they should do. Most clinics that I work with certainly have already got very good practice there in terms of making sure that their clients and their patients are having to seek, for example, independent legal advice and implications counselling, and to have some kind of agreement written down there. So having this all, whether someone is choosing to use the new pathway or not, having them there will certainly place that all within their mind, and hopefully result in just much clearer expectations on what best practice looks like when you are going into a surrogacy agreement. So that's nice to see from the intended parent's perspective. Like I touched on, the improved employment rights are certainly a very welcome addition in the report. At the moment, parents are not guaranteed the same employment rights that you might get, for example, if you're going through with adoption, but to not go into too much detail, essentially this would give them similar rights to those that are adopting, and equal allowance to maternity allowance and things of that nature. So that's really simple and straightforward for them, and very helpful for them. And what I actually hope that this sort of change would also help with is just the general discussion at work about going through fertility treatment and surrogacy. Where that's codified in law, it becomes a much easier conversation to have with your employer, and to everyone, for them to be aware of that. I do a lot of trainings with employers who look at you sort of blank-eyed and glaze over when you talk about surrogacy and co-parenting agreements. And so big changes like this in the law will certainly help to bring that on in a practical sense as well. And then the final change being that the options for dealing with disputes, if you do end up in a court situation, seem improved, and that's very helpful, because what I hope and assume will happen if this does then become law will be some training for sheriffs, judges, court reporters, the people that have to be on the ground and resolving these disputes, and there being some new options there for them will help them to take a much more balanced approach. Certainly the ones I've come across of disputes, you can get almost fearful sheriffs and judges about what to do in these cases because they don't really want to do anything wrong. But what we have at the moment is quite rigid in terms of what you can and cannot grant the people that are involved in a surrogacy journey. So the examples in the reform being a reversal where the surrogate could apply for a parental order, in that case gives the sheriff more options there in terms of what they want to do in a disputed scenario, and also the court being given the power to dispense with the surrogate's consent if it would be in the best interest of the child's very welcome. That's something that I find quite a lot of sheriffs grappling with in a disputed scenario. in Scotland certainly, which is where I'm qualified to speak on, the overarching method of the family court is what is in the child's best interests, and so aligning that with that will make it a much more natural area of law for them to become involved in. They'll probably be less asking me for the legislation when you turn up at a hearing, which would be helpful, and should hopefully make the process of being a disputed court scenario easier for intended parents, although of course you would never be able to wipe that stress off the table entirely for them. And then of course the family court more generally just remaining available to resolve disputes that are unable to be resolved within the parental order process itself, provides a nice safety net that's there for them when they do that. Now, of course, the last bit I'll touch on is just whether the reforms go far enough for intended parents. And I'll preface this with saying that you're never going to be able to make everyone happy when you're looking at an area of law like this. You're going to be trying to fit somewhere in the middle, and that's certainly where we are, and I appreciate that is the case. My views on whether the reforms go far enough are probably that it's relatively modest, is maybe the word I would use for it, when you look at it from the intended parents angle, mostly just because it will mostly benefit the small number of intended parents who go through a UK-based surrogacy organisation with an RSO. So those parents that I chatted about at the beginning, international ones who cannot or don't want to use an RSO for whatever reason, they're not really touched very much by this reform, and so we are pretty much talking about a relatively smaller angle. However, I appreciate that that's probably to try to encourage more people into that sphere than the other two, where it's maybe slightly less risky. However, the changes to the expenses that will get talked about a bit later, I think might have that ability to maybe reduce that number of surrogates that want to go through an RSO if there's quite a large amount of red tape and sort of paperwork to go alongside that. That's just a guess from my perspective. We're already struggling with the number of surrogates that genuinely want to be matched and are not coming through a friend or a family member or someone like that. And whether that would encourage more surrogates to come forward, I'm not sure. I also think that it might be likely to encourage more intended parents to go abroad. Certainly my clients that are intended parents that have chosen to go abroad, the main concern for them is about availability of surrogates, and is that going to then force more to want to go abroad? Perhaps. We'll await to be seen if that does happen. And then the last nugget in my mind, but it's again totally me guessing at this stage until we know what it looks like. Will the costs of engaging with all these organisations maybe outweigh the reward for some intended parents? I don't know how much a surrogacy organisation would charge intended parents to go through this process with them, and will that outweigh what they would otherwise pay to go abroad or to do it themselves with a parental order process, for example. Although a lot of the organisations we work with at the moment are not for profit, it doesn't mean that it's cheap, and sometimes you can actually pay an awful lot more to go through an organisation than you would pay to go through the courts. So it would just be interesting to see the impact that might have on how intended parents choose to go through their surrogacy journey.
Now, our next speaker is Dr. Alan Brown. Alan is a senior lecturer in private law at the University of Glasgow's School of Law. He is author of the book, What is the Family of Law? The Influence of the Nuclear Family.
I've been asked to speak about the proposals in the report on payments, which are in chapter 12, which I've printed out here, which is a nice chunky 60 pages of the report. I just as an aside here, I would like to commend the Law Commission for producing a shorter version of the report. I think they should do that for everything. So Gillian, you should feed that back. So just a little bit of context here. I was quite critical of the consultation paper's approach to payments in an article I wrote in Child and Family Law Quarterly in 2021. So if you've not read it, and I suspect many of you will not have, you can look at that to see what I said about the consultation paper. And one of the things I said at that point was that under the current law, payments sit in an ambiguous position because of the interaction of different parts of the legal system. And I was concerned that under the consultation paper, that would remain. So what I want to talk about in my 10 minutes here is just what does the report actually say about payments, and then to provide a little bit of analysis of whether I think it will address some of the concerns that people have expressed both about the current law and expressed about what was in the consultation paper, because there has been a significant evolution in the Law Commission's thinking into the report. Now, Gillian has summarised some of this anyway, so that will help me skip over some of the things. I want to start off just by noting the Law Commission's point here that their overarching approach has been to seek to provide greater detail on what payments it should be permissible to make to the surrogate, rather than relying on the formula of expenses reasonably incurred found in section 54. And what I think is interesting about this is that it has led, I think, to a really quite a granular level of detail in chapter 12 about what payments are permitted. I frankly wasn't expecting that level of granularity from the Law Commission, because at the moment under the law, it's the exact opposite. At the moment under the law, we have this expenses reasonably incurred phrase, and that's essentially a black box almost, into which it's not defined in the legislation, into which anything can go. So I thought that was interesting that that was the overarching approach. As well as that, chapter 12 mentions 4 overarching principles, and Gillian mentioned these briefly, but I just want to dwell on them slightly. The first is protecting against the risks of women being exploited. And I think we can all agree that this is an important principle, both of the rules on payments and indeed on the law on surrogacy in general. Although the report itself at paragraph 1211 acknowledges that the prevention of exploitation cannot generally answer the question as to whether particular categories of parents should be permitted. So I think that while it's an important overarching principle, it doesn't necessarily get us as far as we might think it does, because of some of the nuances around different types of payment. The next one that has been mentioned is that the surrogate should not be financially worse off. There is then this idea that the costs are those which are typically incurred during pregnancy, or which relate to the fact it's a surrogacy pregnancy. So this idea of what types of payment should be permitted. And then finally, this idea that we can trace back to the Arnot Committee report, that the birth of the child should not be tainted with criminality. So this idea that any sanction, any enforcement of the system shouldn't involve criminalizing of the conduct of the parties themselves within the birth. So that's been in the legal regulation of surrogacy since the 1985 Surrogacy Arrangements Act. Okay, that's the categories of payment that are permitted. Gillian had a much better slide for this with nice pictures and everything like that. I've just got the words. I don't intend to go through these categories, but I just think it's worth putting this up to be like, there's 10 categories here of different types of permitted payment. And just to re-emphasize my point about granularity, this is extensive. And what it goes to, I think, is the criticism of the current law that there's not clarity for intended parents and surrogates about what is and isn't permitted. There's been a real effort in the report to go to that criticism around clarity. If you define a range of categories, you address the point about clarity. As well as those categories, there is also a mention in the report of gifts of a modest nature to the surrogate, which are permitted but are obviously treated slightly differently from the other categories, the nature of a gift being as it is. And then there's also the provisions that Gillian mentioned around intended parents on the new pathway being required to pay for an agreed level of life insurance and being required to meet the surrogate's costs. And I think this is an interesting shift as well, because this is the first time that the law, if this was enacted, the law in the UK's various jurisdictions would be saying certain costs were mandatory in a surrogacy arrangement if it's under the new pathway. Obviously not if it's outside the new pathway, which we don't have at the moment. And the other permitted payments, as Gillian said, are permitted, but obviously in many cases won't apply. So the report then mentions 4 types of payments that are explicitly not permitted, although the report says, and I think inherent in the framework of permitted and prohibited, is that any type of payment that isn't specifically permitted will be prohibited. So these are just examples. They're not it's not an exhaustive list. And I think the first of these is fairly obvious within the confines of the framework that the Law Commission have set out, as is the third one. I think the second and the fourth are slightly more interesting because I think at the moment, expenses reasonably incurred will sometimes capture payments that might fall into the category of compensatory and the category of general costs of living. And I think that speaks to the point that Beverley made about the idea that there might be restrictions on expenses under from the current system under the new system of payments, or at least the feeling of the perception of restrictions, which can sometimes be just as important as the practicalities of it. I thought Beverley's point about the paperwork and the red tape involved was an interesting one, and it speaks to what I mentioned about the granularity of the detail of what the Law Commission have proposed. Whether or not that's the intention of the Law Commission, I think that moving from a system in which the law starts with a very, very undefined concept to a system where the law has this categorized system and might be implying that there will be a level of accounting, and not in a formal sense, but in a sense that, receipts, etc., might be required in some contexts. It might have a perception that there's a significant shift going on here in what is and isn't permitted, even if that's not fully the intention. I want to talk, just to wrap up in the last couple of minutes that I have here, about the enforcement of payments, the parental order system, and the relationship between payments and the legal parental status. So the report recommends that the existing system of court authorization of payments beyond that which is permitted is retained. So this is the system under which, at the moment, the court retains the ability to authorize payments that go beyond expenses reasonably incurred. And that is used by the court either in the context of international commercial surrogacy, where payments made will by their very definition be beyond that, or in domestic surrogacy, where some of the payments made are in fact beyond expenses reasonably incurred. So I think it's just really important to stress that because this is retained, in a lot of cases, particularly international commercial surrogacy cases, there really is no difference in terms of payments. The report is explicit, I think, in acknowledging its own basically lack of ability to regulate things that happen beyond the border of the UK. I mean, and that's probably fair enough. I mean, we probably can't expect miracles in that regard, but it's an interesting limitation. Gillian also mentioned the possibility of civil penalties, although the report does recommend different options in this regard, and the possibility of regulatory sanctions. So there is a clear attempt under the report, I think, to provide a little bit more of a enforcement framework for the restrictions on payments, because one of the criticisms that's been made of the current system is that we have these restrictions on payments that are theoretically in the law, but that actually, because of the lack of enforcement mechanisms, they are just that. They are theoretical rather than real. And I do think, again, though, it's worth mentioning that the civil penalties wouldn't apply in international commercial arrangements. So again, this is about the domestic sphere. And again, just finally, my last point here is about this idea of the surrogate being able to recover payments. Gillian mentioned that, and the report makes clear that the agreements themselves are going to remain unenforceable, but there is this sense that there will be the possibility of the recovery of certain types of payments within the new pathway, that there will be the possibility of recovery. And I think that again is a shift in how we are conceptualizing the underlying agreement, and that works not just from the payments, not just in terms of the surrogate recovering payments, but also in terms of the intended parent recovering. So that's a very quick summary. I think that what we can see from the Law Commission is an attempt to address the points around clarity and the points around enforcement. I think, though, what there maybe isn't in the chapter on payments is grappling with the core tension of surrogacy regulation in the UK, which is lots of intended parents go abroad to countries that use international commercial surrogacy. domestically, we do not want there to be commercial surrogacy, and we just have that tension at the heart of our system. On the one hand, we want to prohibit commerciality, but on the other hand, because of the welfare of the child, when people go abroad, the system in the UK has to deal with those consequences.
The final speaker this evening here is another Alan Inglis. And Alan is a barrister and advocate at Arnot Manderson Advocates, and he's the only specialist family counsel who currently practices in both the jurisdiction of Scotland and the jurisdiction of England and Wales. So he's quite a rare beast, I think we can say. And he's going to be focusing on what the proposed changes mean for people who are thinking about travelling overseas to access surrogacy.
Well, indeed, the conclusion of the other Alan's contribution nicely segues into the topic that I am going to be, the two topics that I am going to be talking about, which are international surrogacy and double donation. The proposals in relation to both of those, insofar as there are proposals, are relatively modest ones. And as well as explaining what they are, I'm going to suggest some disagreements that I have with the approach that has been taken, and hopefully in those circumstances to inject some controversy into this evening discussion. Dealing first with international surrogacy, although the proposals made by the Commission are in fact modest ones, they are central to the main policy objectives of the recommendations in the report as a whole. Surrogacy arrangements which are located outside the United Kingdom are to be exempted from the streamlined pathway which is intended for domestic arrangements. This is clear both in its substance and its intention from the first paragraph of chapter 16 of the report, where it's set out that we have concluded that international surrogacy arrangements should be excluded from the new pathway, as we are concerned by the risk of exploitation, since international surrogacy is beyond the jurisdiction of surrogacy regulation in the United Kingdom. The other aspect which really makes this area of the report significant is the extent to which international surrogacy arrangements are currently occupying the courts in the United Kingdom. There were in 2021, as the report makes clear, a total of 451 applications for parental orders. And it is believed that about half of those were concerned with international arrangements. Anecdotal evidence suggests that the numbers of such cases is increasing. A key difficulty which will remain if international surrogacy arrangements continue through the parental order route arises where the child acquires at birth the nationality of the state in which they were born. They then have an insecure status in terms of UK nationality law until the parental order is granted. And this relates to something which Beverley has already touched upon. The attraction of international arrangements stems from two factors. Firstly, there are some jurisdictions in which the intended parents become the legal parents on the child's birth. Secondly, and I suspect that Beverley is right about this being a factor of future significance, there is a perceived dearth of domestic surrogates. The most significant problem reported by intended parents embarking on surrogacies contracted overseas is the difficulty and delay experienced in obtaining the documentation necessary to bring the child into the United Kingdom in order to apply for a parenting order. The centerpiece of the Commission's proposals for international surrogacy arrangements is that the operational practice of, I was about to say Her Majesty, His Majesty's Passport Office and the United Kingdom Immigration and Visa Service should enable a file to be opened prior to the child's birth to enable a passport for the child to be obtained expeditiously when they are born. This proposal, it seems to me, has the advantage that because it relates to an operational practice, that it wouldn't require primary legislation for its implementation, and therefore could be effected relatively speedily. One of the provisional proposals which the Commission made was that the Secretary of State should have the power to provide that the intended parents of children born through international surrogacy arrangements who are registered as the child's parents in the overseas jurisdiction, and where that jurisdiction's law provides protection of women acting as surrogates and for the welfare of the child, at least equivalent to that provided in the United Kingdom, should have an accelerated process, and that the status of the intended parent in that jurisdiction, in the jurisdiction of birth, should be recognized in this country. It's notable that the criteria that were set out in the initial report, which set forth that proposal, are similar to those which already at common law in this country and in England and Wales recognise orders which determine the person's status. For example, foreign adoption orders where the law is similar in the state in which that they have been made are recognised in this country under common law. The Commission has not persisted in this provisional recommendation, citing, and in fact they attribute this to Dr. Alan Brown, citing that its incompatibility with the policy of encouraging intended parents to undertake domestic surrogacy in the new pathway rather than international surrogacy. It does seem to me that there's an element of what might be described as Canutism here, taking the term from King Canute, because it's not a process, it seems to me, which is actually going to significantly discourage people who cannot find a surrogate in this country from going abroad. It also seems to me that the Commission's concerns are not related to the international element of the surrogacy. They're related to the issue that in some jurisdictions there is likely to be free rein to exploit women. So prominent amongst the countries from which international surrogacy originates in this country are the United States and Canada. And it does seem to me that one can be fairly sure that in those two jurisdictions, the rights of women and the rights of children are as protected as they are in this jurisdiction. And that if one channels international surrogacy into those countries and away from the ones in which the exploitation occurs, that achieves the purpose of avoiding the exploitation of women. The Commission also says that in respect of international surrogacy, it is beyond the jurisdiction of the surrogacy legislation in the United Kingdom. I differ in relation to that as well, because if one looks at the position in relation to overseas adoption in both England and Wales and in Scotland, the primary legislation empowers the Secretary of State or the Scottish Government, depending on which jurisdiction it is, to prescribe adoption from certain jurisdictions. It's striking that the ones on the list are also ones which tend to be suggested as ones in which there is exploitation in surrogacy. Cambodia and Nigeria are currently on the list. So it seems to me that the concerns which the Commission had in relation to international international surrogacy can be adequately protected. Turning to the issue of double donation, this is another area in which the Commission doesn't propose significant change. The law currently requires that there is a genetic link which exists between the child and at least one of the parents. Double donation is where both sperm and egg are donated to a host woman. As the Commission observed, this is of particular relevance to single women who are unable to donate their own eggs and who wish to remain single parents, and those seeking to avoid transmission of genetic conditions. Now, the consultation exercise which the Commission engaged in didn't ask about double donation in principle. It sought views about double donation where there are medical reasons for that to occur. However, it is interesting to read in the report that two consultees did deal with their views about double donation in principle. One of them was CAFCAS, who felt that it was necessary to maintain the separation between adoption and surrogacy because of the light touch of assessments which would apply in surrogacy arrangements. A firm of solicitors who are quoted suggested that double donation was a dangerous step to designer babies. It seems to me that each of these responses is founded on an unevidenced belief that children are at greater risk than parents who are not genetically related to the children for whom they are caring. It may be that I have a slightly jaundiced view in relation to that because my work is principally concerned with children who have been abused by parents who are genetically related to them. But I do not think that one can assume that adults who embark upon an arrangement involving double donation are ones who require a greater degree of scrutiny than others who engage in surrogacy. The Commission concluded that we recommend that the requirement of a genetic link is maintained. In reaching that conclusion, we have been heavily influenced by the difficulties and disadvantages in seeking to tie double donation to a need for medical necessity. However, if the link between double donation and medical necessity is severed, it appears to me that there is no difficulty in suggesting that double donation is something which could occur.
We have tried and deliberately set out a very, very detailed scheme for surrogacy here, and Beverley alluded to that. And I'm very conscious that it's quite a different approach to that taken in other jurisdictions which have recently reformed surrogacy, including New York and New Zealand, which have been quite light touch, particularly New York. And we have really tried to explore all the permutations, all the possibilities, all the consequences. And we hope that for the vast majority of people using surrogacy, these will not be necessary, but the detail is there. And that included looking at matters such as employment law, immigration law, succession law. Beverley made the point about the carrot of intended parents being recognised as the legal parents. And I just want to draw out that, of course, that's a significant carrot for surrogates as well. And the clear evidence from surrogates is that they are not happy being recognised as the legal parent, and particularly for the several months it takes for the parental order. So we hope that this is very much the benefit of both the surrogate and the intended parents. And I also wanted to just emphasise that we're very aware that a lot of surrogacy teams do want to match independently, and that still remains a possibility for them. If they do want to match independently and get together independently, they're not precluded from using the new pathway if they're then willing and happy to work with a regulated surrogacy organisation. So it's not the independent matching which would exclude them, but if they didn't then want to work with a regulated surrogacy organisation and go through the required screening and safeguarding, then the new pathway would be closed to them. But they can still match independently and come into the system at a later stage. In relation to some of Alan's points, I just want to draw out the fact, one of the things we were very careful to do in relation to payments is to separate out any enforcement of payments from recognising the legal parents of the child. And at the moment, the only thing the courts can do to enforce or impose a penalty for overpayments is to refuse to recognise the intended parents as the legal parents of the child. And we were very clear we wanted to make a distinction there. So the courts can now recognise the intended parents as the legal parents, while still seeking to recognise that any overpayments. So that was one thing we were very keen to do. I just wanted to clarify something also that Alan said. The intended parents are required to offer to meet the costs of the surrogates, screening and safeguarding, and her life insurance and critical illness, but it may be that she doesn't want to take them up on that offer. So actually, it won't be a completely compulsory cost for them to meet. And I just wanted to flag that up. That is quite an important distinction. And we can imagine, particularly in a family situation or where the surrogate has her own critical illness and life in cover in place anyway, she wouldn't need to take the intended parents up on that offer. But if she does need it, then they are required to offer to pay for it. We were also very keen, you flagged up the general cost of living, and we think that's very, very important, that no woman should ever turn to surrogacy to support her life and her cost of living. So surrogacy should be a genuine choice and not one driven because she has no other way of meeting the rent or the food bills or whatever. And of course, we're all aware of the economic climate in which we're currently working. So it was quite important to us to make a clear distinction between the costs related to surrogacy pregnancy and costs of living. This relates to both comments from Alan and, well, both the Alans, in fact. We're very conscious we can't regulate overseas surrogacy and we can't regulate beyond our borders. All we can do is try to improve the position in the UK so far as we can. So that led to the recommendations, for example, in relation to HMPO and the visa and immigration. We were also conscious, though, that commercial surrogacy has been recognised and legitimised to some extent by the Supreme Court in the Whittington decision. So we didn't want to close the doors to overseas surrogacy or to commercial surrogacy, but we also recognised that there's a limit to what we could do in relation to regulating that. And the final point Alan made about double donation, I think because there was no specific consultation question on it, our hands were to some extent tied as to what we could recommend, but we've given a fairly clear steer that this is something the government may wish to look at when it comes to implement the bill. So we shall see if anything shifts when it does reach parliamentary stage, if it gets that far.
So first of all, we had Pauline Everett, who asked very quick off the mark, why is double donation being denied to commissioning couples and single people who need it to found a family under Article 8 of the ECHR? So we have that one, and then I'm going to go to another one, the one which is from Kirsty Horsey, who asks, was it ever considered that an exception to the double donation position might be appropriate for intended parents who've already started a surrogacy arrangement using embryos created from at least one of those two people's gametes, but then they subsequently find themselves, e.g. after unsuccessful transfers, without those embryos, unable to create more?
We did spend a long time discussing double donation and the complexities there, and we looked in particular at how other jurisdictions deal with it, in particular New Zealand. I think, though, the bottom line is that we just didn't have an evidence base that there was a groundswell of support for double donation. And without that evidence base, we didn't feel in a position to recommend any change to the law. So all we could do was recommend the existing law to be maintained, which does require a genetic link. And the problem there, as Alan Inglis summarised, was that the question on double donation was very specifically in the context of double donation where there's a medical necessity and not just where there was no medical necessity. And we realise that that does count against, for example, single intended parents, particularly women who might need surrogacy because of a lack of uterus and eggs. So it might count very clearly against them. And for that reason, I think we felt that there was definitely scope for the government to revisit this. Can I also just come in? I think, sorry, Sarah, there was a question about double donation where the intended parent with the genetic link had died. And this is what I meant when I said earlier about how we have tried to be exhaustive in our report, because there is a section, and it was incredibly difficult to deal with, on death. So we looked at what should happen where one of the intended parents or both the intended parents die, what happens if the surrogate dies, what happens if the child dies. And we have made provision if the intended parent with the genetic link dies, the arrangement can still proceed. So there will be protection for an intended parent in that situation where they have started off with a genetic link, but that intended parent has died.
The next question is from Vasanti Jadva, and she asks, will the surrogate register or surrogacy register also enable the surrogate's own children to connect with the surrogacy-born children? If so, is this only for those related genetically, or does it also apply for gestational connections?
Yes, where all parties consent. So if you consent for your details to be released to any other children born of that surrogate, including their own children, non-surrogate born children. And we've also made provision for surrogate born children to find out if anybody that they're about to enter into a relationship with is born of that same surrogate, whether genetic or gestational. And we recognise that for some it might be the gestational connection rather than the genetic one, which is important. So the surrogacy register will enable that information to be accessed, but it would require the consent of all the parties. So you can't just, it will be a closed register, you can't just browse it for obvious reasons, but if you have the consent of all parties, you can access that information.
And so I think that probably ties into a question from Catherine Wade, Gillian, who says she's not clear on whether the surrogacy register records whether the surrogate was traditional or gestational.
Well, and that might be a level of detail too far at this stage. I think our intention is that it should, but we have also left some of the detail for the register to be dealt with through regulations and through the HFEA. But I don't see any reason why it wouldn't record that information. It would also sit alongside the current donor conception register that the HFEA records. So if there was no record of a donor egg in that register, then it might also reveal that it was the surrogate egg that was used.
I do think there are some really interesting questions around the register and around like the identity implications for the children involved. And this is something that Catherine, actually, who asked the question, and I have written about in a different context. And I think particularly it's interesting, what Catherine's getting at is that at the moment in the legal regime for the registration of donors, what the law is seeking to capture is genetic connections, genetic heritage, and have records of genetic, so you can find out information about the people who are your genetic progenitors. And obviously there's going to be an extension here in the context of the surrogacy register that you're going to be able to find out about gestational origins. And I do think that this is really more of a comment than a question. I just think it's quite a radical step in some ways, because it's a different category of origin, and prior to this I think the law has drawn quite a bright line distinction, and I do wonder if there are any implications more widely about origins, in terms of, we know, as Sarah mentioned at the very start, that families are being formed in complex ways, increasingly diverse ways, and in terms of the identity of people, what sorts of information can be subsequently accessed, particularly when these are arrangements that are facilitated by the UK government through licensed fertility clinics. There are interesting questions there. The Law Commission obviously were only asked about surrogacy, but I do think there's a lot of interesting implications.
The next question is from Pauline Everett, who says, if a surrogate decides to keep the baby at the time of birth, why are the commissioning parents the legal parents?
If she decides before the child is born during the birth that she wishes to withdraw her consent, then she would be the legal parent at the moment the child is born, if that withdrawal of consent has been recorded. If she changes her mind after the child has been born, then the intended parents would be the legal parents, because that was what the parties had agreed, and that was their shared intention at the point of conception. And her consent to that was continuing throughout the pregnancy and at the point of birth. So if she hadn't withdrawn her consent at the point of birth, then her consent was continuing to the intended parents being recognised as the legal parents. And we were very clear that once the child has been born and the legal parents have been identified, either as the surrogate or as the intended parents, it shouldn't be up to the parties through any unilateral actions of their own to change the legal parental status. There's no other situation in law where the parties themselves can change who the legal parents of a child are. You can't enter into a contract to change the parents of the child. So after the child has been born, the only people who can change the legal parents would be a court, whether that is through an adoption order in a totally different situation of adoption, or whether it's through a parental order in a surrogacy case. So the surrogate's consent at the moment of birth would determine whether she is the parent or not. If she's withdrawn her consent before the birth, or at the point, before the child's born, then she would be the legal parent. If she has not, then at the point of birth, the intended parents will be the legal parents, which reflects, of course, the shared intention of all the parties at the outset on the new pathway. And if she does then change her mind, any decision as to legal parental status would go before the court.
So the next question I'm going to go for is from James Duffy, who says, does the panel believe that these changes will encourage an increase in the number of people opting to be a surrogate? Was there discussion in preparation of the report whether equivalence should be applied to surrogacy in an international setting? Without this equivalence, I anticipate the further increase in people travelling abroad. What are the parents' views?
I think that it will likely not decrease, but I don't think it will necessarily increase either when we're talking about UK-based surrogates. Apart from the obvious of there being better facilities in terms of what we do with legal parenthood on birth, I don't think that the law is so bad at the moment that it prevents somebody who would be a surrogate. They're not looking at it now and saying, oh, well, I would be a surrogate if I just wasn't the child's legal parent on birth. I think that it comes with the whole facility and setup of what the law comes with, and there's so many different interacting parts of what might change when you look at this and about how that might impact on a surrogate's decision. Still think it's more common to be a surrogate because you are doing it on an altruistic basis for someone that you know, whether that's a friend or a family member or somebody that you have met. And so I don't think that it will necessarily have an impact on the surrogate's view on whether they will become a surrogate or not, but I think it will certainly have an impact on the intended parent's decision as to how they choose to seek a surrogate match. And like I'd said in my presentation, I do think that it won't necessarily encourage people too far into going down the new pathway if they already are struggling to be matched with a surrogate, and that really is the underlying problem, is the lack of surrogate availability in the UK, and I don't think there's anything in the new law that's going to necessarily increase that number.
I think that the decision to become a surrogate in the United Kingdom is very unusual, and I don't think that it is likely to be encouraged to increase by the proposals, which I suspect very strong that people would only know what the proposals are once they'd made the decision and were looking into it more fully. But I also think that there's going to be an increase in international surrogacies, because of the non-availability of surrogates here.
I think there is a tension at the heart of the Law Commission's report that this actually indicates, which is that one of the things that is said is that the Law Commission want to encourage domestic surrogacy arrangements and discourage international surrogacy arrangements. And they a lot of, I think, the way in which that's been focused is on encouraging intended parents, i.e. through the new pathway and through the carrot of legal parental status. What I think they're less, though, is encouraging, if you will, people to act as surrogates. Because it's one thing to encourage intended parents to use a domestic surrogacy, but it's not just the legal regime that acts as a limitation on the use of domestic surrogacy. It's also the availability of people to be surrogates. Whereas in the international context, you have a globe, in an increasingly globalized world, you simply have more access to potential surrogates. And I think the tension here is that, frankly, the biggest inducement to act as a surrogate would be something that the Law Commission has explicitly ruled out, which is financial inducements to act as a surrogate. So that's, I think, the tension here. We want to encourage domestic surrogacies. I say we, the Law Commission, but they don't want to change the rules around commercialisation. And I think that is a core tension that underpins this whole question of whether or not there will be more encouragement under the process.
Would the panelists like to have seen a move to a more commercial model in the UK then?
I think that the whole issue of money is very difficult because it has always been the case that by the time the matter comes before the court, no matter how much has been paid, the child's best interests at that stage is so obviously in making the order, whether it's a parental order or an adoption, that I mean, I can't think of a case in which an order has not been made because of the amount of money that has been paid. I'm aware, because I've been doing this job for a very, very long time, that there is a case in about 1972, a decision of Dame Margaret Booth, where she did refuse an adoption order when the law was the same, but she'd taken a dislike to the adopter in any event. But she pinned it on the scale of the contribution that had been made. But I mean, as the law currently stands, I don't think that the issue of money induces respect into the process, because what the law actually says is consistently ignored. So I think that it's a brave attempt by the Law Commission to try to put a structure around a completely undefined current provision. But I also agree that I think if you want to increase the number of available surrogates, the best inducement is a financial one. The other thing about international is that in some other jurisdictions, surrogacy is a much more open and widespread activity. And I think that in itself encourages people to think, oh, well, perhaps I'll do that. That doesn't happen in this country because you don't very often hear about surrogates.
Whilst I appreciate that my view comes more from just being on the ground with people and seeing the kind of messy reality, essentially, of what surrogacy agreements are like. And I find it difficult because whilst I'm not fully of the view that it should be a fully commercialised approach in terms of, I don't think that you should be able to fully make a living from being a surrogate, for example, the exact things we've talked about, you would never want somebody financially pressurised into being a surrogate. However, realistically, if you are not doing it because you're doing it for a friend or a family member, there is a huge amount of time and effort involved in being a surrogate. And there needs to be a line, in my view, somewhere between that. I don't think that you can have a purely altruistic or a purely commercialised surrogacy arrangement, and there are jurisdictions in the world that do that relatively well, where they walk the line between exploitation and equally fairly compensating surrogates for the time and effort that's involved in that, to an extent that they would still wish to do it if they didn't have another link to the couple that they were doing it for that particular reason. Meanwhile, though, always acknowledging that the UK government's approach has always been about altruistic surrogacy to a certain extent. The Law Commission have their arms tied by that. But I do think that the current approach is a good balance there on payments in terms of that, where the court can retrospectively action payments. They can take a fair view on what is a reasonable expense. And I think that putting a lot of tape and granular detail, like Alan had already discussed, might be enough to put off a surrogate to think that they might otherwise be forced into making quite detailed spreadsheets and receipts and things like that. Whereas some modest amount of that, I think, would be reasonable for this kind of arrangement, particularly where we're also, in terms of what the Law Commission want to do, implementing a quite detailed regulatory scheme with the HFEA and regulated surrogacy organisations, which between them should have the ability to identify whether a surrogate coming into the arrangement is being or has the ability to be financially incentivised by it, and could therefore be screened out at that early stage.
There are a few questions about passports. So there's one from Heidi Burrows, which says, can you clarify the Commission's recommendation about children born via international surrogacy's nationality and access to passports? Even if born British, currently a passport can take up to 4 months with parents and newborns waiting overseas.
We are very clear that it would not be appropriate to apply for a passport or a visa in respect of a child before they've been born. So there's no proposal to apply for anything before the child's been born. But we're also conscious that in order to get that passport or visa, you need to open a file. And we propose that you should be able to open a file and start gathering the relevant documentation. So parents' birth certificates, parents' marriage certificates, etc., and get that information together. We're also aware that a lot of the practice around bringing children back into the UK once they've been born overseas from surrogacy is based on practice rather than any sort of statutory basis. And again, we're trying to capture that so that it's not just a hit or miss as to who's on the arrival's desk at Heathrow the day you arrive, but that it's actually then captured and is recognised and admitted. We are conscious that it can take a long time for intended parents to return to the UK with their child after an overseas surrogacy, and while we can't recommend actually applying for a passport or visa before the birth of the child, we hope that processes can be streamlined and better guidance can be produced and consistent guidance can be produced by the relevant government bodies to help that happen.
So Chiara Marley asks, just to clarify, are the intended parents named on the birth certificate instead of the surrogate? Is this irrespective of genetic relatedness in the case of donated gametes?
We put forward 2 recommendations in the report as to what should happen on birth registration, and our preferred recommendation is that the intended parents are on the new pathway only, not if they need a parental order. But on the new pathway, the intended parents would be recognised on the birth certificate as the legal parents, and they would register the birth. We're conscious that might not be something the government is willing to take forward, so we have made an alternative provision if that doesn't happen. But the critical thing, I think the second part of your question there was, it's not related to their genetic connectedness to the child, although their double donation is not permitted, so at least one of them will have to be genetically related to the child. The thing that would permit them to be on the birth certificate under our preferred recommendation is the fact that they are named on the regulated surrogacy statement, and they're the ones who've entered into this regulated surrogacy agreement with the regulated surrogacy organisation. So it's that approval by the RSO at the outset, which would then see them being recognised as the legal parents at birth and registered on the birth certificate if our preferred recommendations are implemented.
If the government because they want the coherence of the birth registration system. We have a situation where the intended parents will be the legal parents at birth, but they'll not go on the birth certificate. I find that fascinating. That's really interesting. But actually, the more interesting one, Gillian, to me, is the recommendation that we use the word parent for both intended parents on the birth certificate. We don't use the gendered descriptors, because at the moment, that only comes up in the context of female same-sex couples under the 2008 Human Fertilization and Embryology Act, where the second female parent is labelled using the gender-neutral word of parent. So I wondered, just to abuse my prerogative here on the panel, I wondered if you could talk us through a little bit what made the Law Commission recommend parent as the word rather than mother and father if it is an opposite-sex couple.
There are other situations where you could be a legal parent without being named on the birth certificate. A married husband, for example, is still a legal parent without being named on the birth certificate. So there is precedent for it. So we're not going absolutely freestyle in our recommendations here. There is legal precedent for that. We're also, and this came up in some of the questions about the donor register in relation to surrogacy register. Registration of identity in relation to genetics and gametes and birth registration were two areas where really the whole question needs to be looked at in a much wider context than just surrogacy. And we were very limited by only being able to look at it in relation to surrogacy. And in fact, I think there's probably, there could be a case for a review of birth registration as a whole. And in that situation, you could then explore whether the words parent or mother, father, etc. are appropriate on that birth certificate, Alan. Thank you.
What might be the elements of best interest to be considered if IPs make an application for a parental order if the surrogate withdraws her consent? The child may or may not be living with the IPs from birth. What other considerations will enable a decision to be made as to what is in the child's lifelong interests?
So, I mean, I'm not sure there's a clear answer to that, because this is something that courts are required to grapple with every day. What's in the lifelong best interest of the child? I mean, the one thing I wanted to pick up on, though, is that in order to make that parental order, the child must be living with the intended parent. So in order to make the parental order in the best interest of the child, to recognise the intended parents as the parents, the child must be living with them. And that goes quite a considerable way to consolidating the current family situation that the child is in and the wider kinship network that they're already developing in a very practical context.
In English law, there are clear models, aren't there, in Section 1.3 of the 1989 Act and in Section 1.4 of the 2002 Act. There are checklists with the obvious caveat to consider all the circumstances of the case, but there are lengthy checklists which direct the court to what are the factors that contribute to an evaluation of what is in the child's best interest. And there's no reason why those couldn't be used as a model in any amendment to this Act.
And then I'm going to, perhaps this will be our final question from Alison Motluck, who says, to safeguard the altruistic model, has anyone recommended that fertility lawyers and fertility doctors manage surrogacies in a non-profit making fashion? And if not, why not?
I'm going to answer that question with something I learned on a PET seminar once several years ago. So this is just how important and valuable PET seminars are. And when the Arnot report was published in the 1980s, the expectation was that all fertility treatment would be carried out on the NHS and it would all be publicly funded and publicly overseen. And I think our approach to surrogacy might be very different if that were still the case. I'm also conscious that there are differences north and south of the border, and Beverley and Alan can testify to the fact that actually publicly funded fertility treatment for surrogacy is available in Scotland, and that couples can go through NHS fertility treatment for surrogacy in Scotland. So whether that becomes available in other jurisdictions is not something I can comment on, of course.
Profit is what lawyers call their salary. And in those circumstances, I mean, I obviously agree that it shouldn't be inflated in any way, but you can't expect people to work for nothing any more than you can expect a surrogate to work for them.